Okay, let's get started. Good afternoon. Thank you for joining us today for Drugs and Partying, What Contractors Need to Know About Medical Marijuana and Office Parties. I'm Jon Landesman, a partner here at the firm, co-chair of Cohen Seglias' Labor and Employment Group.
Good afternoon. This is Anthony Bottenfield. I'm an associate here at the firm and a construction associate.
So the slides for today's webinar are available in the handout section and will also be included in the follow-up email. In that email, you will also receive a link to the recording of this webinar. Should you have any questions during the program, we want to hear from you. Please ask them in the questions section of your GoToWebinar panel. We'll address the questions to the extent that we have time as they come in. And really, we are here to answer your questions. So you should be able to follow along also with the slides that we have. And we just changed the first slide, and you have a picture there of me, as well as a picture of Anthony. And I guess just by way of background before we get started, so as a member of the Labor and Employment Group, I work with employers of all sizes to help them with really any and all problems or issues they have with employees or unions. And that would include drug testing, as we're going to talk about today. It would include discrimination issues, non-competition agreements, wage and hour issues, really the whole gamut, anything that has to do with labor and employment law.
And this is Anthony. Just want to welcome everyone again to this webinar. My understanding, we have clients that have dealt with the firm in the past, as well as others on the line, and welcome everyone. My practice includes representing clients in all aspects of construction, from contract review and negotiation through advice during the construction process, claim procedures, litigation, arbitration, mediation, all through trial. Whatever our clients need, I'm here to assist in that manner. So first of all, we just want to kind of go through what's on today's agenda. The first topic that we're going to go through, and maybe a little bit more detail than the second, is laws regarding medical marijuana use in the area and throughout the country. It's an area that everyone has a lot of questions about. It's changing constantly. It's a relatively new area of law, and so it's something to really, as employers and employees, keep your finger on the pulse as to what's going on and what's changing. And that's kind of the first goal today, is to kind of give everybody the up-to-date law as where we stand, and some advice on how to handle that, and to make sure you're plugged in the future. And the second part, which is probably pretty timely right now as we approach the holiday season, is how to handle holiday parties and other office parties, and issues that can come up there, especially in the sexual harassment area of law. So we're going to jump right in. As we talked about before, if anybody has any questions, please raise them. We're here to kind of give you that overview, and as we say here, not try to turn anybody into lawyers, but we want to hear from you and answer those questions. And if you don't answer it, if you don't ask it today, feel free to drop either of us an email in the future. Pick up the phone and call us. We're happy to share our knowledge on these topics. So I'm sure your office will look like this after this presentation. We have Cheech and Chong here, of course, enjoying themselves. Topic one is cannabis and medical marijuana. So the term marijuana has negative connotations for some. Kind of harkens back to a day when it was treated, in a discriminatory way, and some think that people use the word marijuana to kind of discriminate against those of maybe a Hispanic background. And so some think that we should use the word cannabis, it's the scientific name, and stay away from marijuana. I don't know that there's really necessarily a big, that's a majority of opinion. I think marijuana is a pretty, safe and interchangeable name, but that kind of says a little bit of history to it. And there's two plants that you see here, cannabis sativa and cannabis indica, and they're used differently in the medical field to treat different, ailments and symptoms and whatnot. So states, as I'm sure you know, have gradually legalized cannabis throughout the country. And so you have, states like Colorado that were kind of on the forefront, sticking their toe in the water and everybody else kind of sitting back and watching. Some states have referendums, some enact laws with varying degrees of accessibility, whether it be medical marijuana, whether it be medical and recreational, or whether it's still prohibited in all ways in some states. So you can see here, it got kicked off in California in '96. Today, there's 34 states and territories, and in 14 states at this point, recreational use is permitted. And all signs lead to that just continuing to increase, whether that is an explosion or whether that is states continue to, trickle in their legalizing it on a recreational basis. And here it just gives you a map and kind of more of a visual as to, based on the key there on the right, color-coded, which states allow what kind of use.
And I guess I'd just add, Anthony, that, depending upon what happens during the next presidential election cycle, it may no longer be a state-by-state issue. We could be looking at reform on a federal level.
That's a really good point, John. We're going to get into that in a second about the rub between federal law and state law. And I think that is when I talk to people about this subject and just mentioning that I'm doing this webinar or CLE or what have you is, yeah, but it's so strange because it's actually technically illegal under federal law, and that's what everybody kind of points to, and it's a valid point. And so maybe if we have a switch in administrations, there'll be federal legislation enacted, and then maybe we won't be having webinars like this in the future because it'll be a little bit more clear cut. But so as we said, cannabis is illegal under the Federal Controlled Substances Act, and what that does is lists out certain legal substances by schedules. And so Schedule 1 is what they consider the harshest, most regulated, down through Schedule 5. Marijuana is still on Schedule 1, so things like it's in the same category as things like heroin, where a drug like fentanyl is a Schedule 2 drug, believe it or not. It seems pretty antiquated, but doesn't seem to be too many changes to this federal law, so it's just kind of sitting until something gets done. We said marijuana, technically illegal under federal law, despite all the states enacting legislation and courts interpreting that legislation. It's still technically illegal. One thing that I remember when states started passing these laws was nobody wanted to touch the money that was being made off of it, whether medicinal or recreational, because banks thought, am I going to get charged with a RICO claim, a racketeering claim, or money laundering or something like that because it's illegal. I feel like with enough states getting in the game, and the way the trends are going, there's a lot less fear about that now. And as we see, the headlines of how much money is being made in states like Pennsylvania through this industry. And so this last point here, this is more of a legal term of federal law preempting state law, which basically just means if you're looking at the hierarchy of law, the federal law, if the federal law and a state law conflict, usually the federal law is going to preempt that state law unless there's something in the federal law that makes an exception for it.
And not to get overly technical or trying to turn everyone into lawyers, but that's really legally what we're going to focus on now for the next few slides. You're looking at federal law, the Controlled Substances Act, that says marijuana is illegal. And then on the other hand, you have all of these states, 34 states and additional territories, that to some extent have legalized marijuana, either for medical use and or recreational use. So does the federal law preempt or essentially supersede the state law? That's one of the questions that the courts are struggling with.
And so, this webinar has a strong focus on the employer-employee relationships. You can talk about medical marijuana, recreational use of marijuana in many different aspects, but we're going to kind of just focus on that employment situation. And a seminal case on that came out of the state of Colorado in the Supreme Court. It was Coates versus Dish Network. Coates is the last name of the employee. Obviously, we all know Dish Network as the cable network. And so this was in 2015, and the state of Colorado had the law that medical marijuana was legal. And despite that law, Mr. Coates was terminated when he tested positive for marijuana. And this gained a lot of attention because Mr. Coates was, as we say here, had a stellar employment history. He was a great employee, really thought well of, and he had a legitimate handicap. If you saw on that first slide, he's in a wheelchair, and he's using this legally to aid in his medical condition, yet was terminated, in the Supreme Court of Colorado upheld that termination as being legal. And so just before this decision, a number of states, in 2015, not that long ago, just 4 years ago, were enacting specific laws to protect employees for medical cannabis users. So, it's the states saying, look, what's the point of having these medical marijuana laws that permit it when an employer can just fire somebody at will for somebody using, testing positive? If the state, if we as the state thinks it's important enough to allow these people to use it, on a medical basis, we can't allow employers just to fire them because they don't like somebody that uses marijuana. And so after this decision, a lot of states paid attention, and it drove them enacting these laws that protect employees. And so, as we'll see, we're going to take a little bit of a deeper dive into Pennsylvania and New Jersey and to see what they say about how that affects employees. And so, we say here that again, the rub of federal versus state law, and there's been, pro-employee and pro-employer rulings. And so, like we said, there's these anti-discrimination laws saying that you can't just up and fire somebody just because they're a medical marijuana user. And the example here is from a Connecticut case. It's basically saying you can't just be, it's not illegal per se to employ, a medical marijuana user, or that this federal law regulates employment practices. Now, the issue has become at this point, and I imagine it will shift at some point if we continue down the path that we're going, is that it extends to medical marijuana users, but not recreational users. So if you're in a state that permits medical and recreational use, that you don't have the medical use as an employee, that doesn't necessarily protect you. You're not in a protected class, and that the employer can still terminate you without violating the law. And so I'm going to flip it over to Jon at this point. He's going to talk a little bit more about the Pennsylvania Medical Marijuana Act and some specifics for that state.
Thanks, Anthony. And we've chosen to focus on two states here. So first Pennsylvania. Next, you'll see we're going to discuss New Jersey, just as sort of examples, and also because a lot of the participants that are on the line operate in those two states. So first, looking at Pennsylvania law. Pennsylvania has what I would call a fairly common sort of anti-discrimination provision. So Pennsylvania, of course, allows for individuals to obtain licenses to use marijuana for medical reasons. And the law says essentially that an employer cannot discriminate against an employee because that employee has a license to use medical marijuana. And, does that mean that an employee can show up to work under the influence or high? And the statute in Pennsylvania specifically addresses that question and says that no, if the employee's under the influence, then we can have a policy in place and the employer does have the right to discipline or terminate the employee because the person's under the influence at work. Although it's not specifically addressed in the statute, would we have the right to discipline or terminate someone because of, let's say, not being under the influence, but possessing marijuana or possessing other drug paraphernalia? I think the answer would be yes, that an employer has the right to implement and enforce those sorts of policies. And we're going to talk about drug policies in a few moments in more detail. Still focusing on the Pennsylvania statute. So what if I have a company that does excavation work and they employ a number of drivers who have to operate a triaxle dump truck? Those people, of course, are covered by DOT regulations. You could think of other drivers, over-the-road drivers, or heavy equipment operators, crane operators, people who are subjected to mandatory DOT testing. If they test positive, does the Pennsylvania law say that I have to excuse them and overlook their positive test because of the anti-discrimination provision that we just looked at in the Pennsylvania statute? And fortunately, the statute answers that question for us and says that we do not have to create an exception. So in this instance, where federal law, such as the DOT regulations, specifically says that an employee who occupies one of those safety-sensitive positions, like operating a heavy equipment or a truck driver, we can go ahead and we can terminate that individual or discipline the individual if they test positive for drugs, even if they have a license or a prescription to use medical marijuana. Now, the law in New Jersey, let's take a look at that. And Anthony mentioned earlier that this is an area of the law that's changing rapidly. Well, New Jersey is a super example of how quickly the law is changing, because if we gave this seminar a year ago and we were talking about New Jersey law, we would be giving a completely different presentation. So what was the state of the law in New Jersey prior to July 2nd, 2019? Well, we have the New Jersey Compassionate Use of Medical Marijuana Act, which legalized marijuana use for medical reasons. But unlike the Pennsylvania law that we just looked at, did not have any protection for employees. So the way that the statute was written by the legislators in Trenton essentially said, yes, it's legal to use medical marijuana if your doctor prescribes it, but if you test positive, the employer has the right to terminate you. Well, of course, an employee was terminated, and what happened? The case goes to court, and ultimately, the New Jersey Superior Court, in the case of Wild versus Carriage Funeral Holdings, said no. Even though the law doesn't specifically allow an employee or protect the employee in that situation, the court determined that the employee was protected, and the court said that it would be unlawful to fire them. So you have the statute that essentially says one thing, and a court trying to fill in the gaps and say something else. It leads to confusion. It leads to employers not knowing what to do. And so what happened? The law was amended, and that's a good thing to provide some clarity. And it was renamed the J. Koenig Compassionate Use of Medical Cannabis Act. And it explicitly provided the employee protections that the court had allowed for in the Wild case. So now the New Jersey law, just like Pennsylvania law, prohibits employers from disciplining or firing an employee solely because they have a license to use medical marijuana, or if they have a license and they test positive, we can't terminate them. But again, just like the Pennsylvania law, the statute in New Jersey specifically says that if the people are under the influence while they're working or during working hours, that they're not protected and they can be terminated. Anthony, it looks like we have a question from one of our many participants. It looks like they're actually coming in rather rapidly.
Yeah.
Why don't we address a couple of the questions before we move to the next slide?
So it's interesting that you just ended with that point, John, because our first question is saying that you can't be under the influence at work, but what about drug tests? I mean, can you prove that they're under the influence versus it just being in their system from a prior use? And we're actually going to get to that very shortly when we talk about testing and the difficulties with the testing.
Right. And I think to give you the sneak peek answer is, if the person tests positive and they have a license to use marijuana for medical reasons, unless you have objective evidence, strong objective evidence that shows that they were under the use or under the influence at work, then my advice to that client or that employer would be not to discipline, not to terminate the person because they tested positive. It would be our burden of proof going to court to show a judge or a jury or an administrative agency investigating this that the person was in fact under the influence. So that would involve what's objective evidence. Well, it wouldn't just be poor job performance, erratic behavior, someone who has a pattern of poor job performance coupled with erratic behavior, perhaps coupled with physical observations from supervisors with bloodshot eyes, things of that nature.
You can imagine how difficult that is from an employer standpoint to evaluate. Most of the people on the line here probably aren't in the best. They're not trained professionals to visually observe people under the influence of marijuana. So it's such a difficult situation, and this must be a popular topic. Our second question is mirrors that of the first one. Here's another question that's interesting. Does the employee have to inform you that they have a license to use?
So do I want to have an across-the-board policy that says that all employees who work for my organization have to come forward and say, here is, I have a license to use? I think the answer is no. And why do I say that? Well, the Americans with Disabilities Act and other state laws concerning disability prohibit employers from making inquiries regarding their employees' medical conditions um, and or prescriptions unless they have a legitimate non-discriminatory business reason for doing so. And I'm very closely paraphrasing the statute when we talk about legitimate non-discriminatory business reasons. So what could be a legitimate non-discriminatory business reason for making such an inquiry? Well, if we are making that inquiry in connection with a drug test that we're implementing, that would be a legitimate inquiry. So if it's employees that are subjected to drug testing, or if we're making the inquiry because the person occupies a safety-sensitive position, including but not limited to such a position that's covered by federal regulations like the DOT regulations that we mentioned earlier. So if I have an employee who is operating heavy equipment or a truck or performing some other safety-sensitive position, would I then be okay to ask them about their possession or non-possession of a license to use medical marijuana? That would be permissible. Again, it's justified by a legitimate non-discriminatory business reason. So let's try to keep on track here. So we were talking about New Jersey law. There's some other nuances in the New Jersey law, just like all the other states have their little differences here. The New Jersey law says that if the person tests positive, we have to give them written notice. We have to give them a 3-day opportunity to provide us with an explanation, and it defines what's a legitimate medical explanation. When we're talking about marijuana, we also have to be aware of the Americans with Disabilities Act, and we've mentioned the ADA, which defines disability. It also says that employers need to provide qualified individuals with a disability with a reasonable accommodation to enable them to perform the essential functions of their job. And so under the ADA, how does this fit in? What are we talking about here? Well, let's say we're dealing with a state that allows medical marijuana, but it doesn't have the anti-discrimination piece to the statute yet. So the law in that state says you can use medical marijuana with a license, but it doesn't specifically prohibit employers from discriminating against employees who have such a license or who use marijuana. Most courts have interpreted the ADA to say that the reasonable accommodation requirement does not protect that employee, but there are courts out there, including, for example, in Massachusetts, where a judge, some would call that judge an activist judge, has interpreted the ADA to essentially create an anti-discrimination provision in the law and say that we have to provide reasonable accommodation, i.e. not terminate the employee who has a license for medical marijuana, even though the legislature in Massachusetts hasn't specifically gone that far. So we talked about this earlier in terms of drug testing. Marijuana, unlike other drugs, it can remain in your system for weeks, even though the high or the impairment doesn't last that long. The results vary across different people. There's different ways to do the testing. Blood testing is one such way, and it varies in terms of its accuracy. If the person was smoking or using a vape, vaping it or otherwise, and so there's inherent difficulties, and clients are asking all the time what sort of tests. There are other newer types of tests that are out there in terms of saliva tests, blood tests, but those tests in terms of their frequency pale in comparison to what's the most common test is the urinalysis test. Why is that? Urinalysis is fairly reliable, it's common, and I guess the other big thing is it's relatively inexpensive. Do we have any other questions that we wanted to get to, Anthony?
We do. We have a couple questions in dealing with kind of who falls within and out of, safety concern positions. And so one question is, can a brand ambassador who goes on different events and shows with a license, can they be terminated? And if so, can this be communicated as the reason? They say, I understand that brand ambassador is a safety sensitive position, being that the brand ambassador goes on public events and shows.
Okay, so a brand ambassador, what do you think, Anthony, a brand ambassador would do?
So my thought would be a brand ambassador would be someone that is maybe in sales for a company that goes to trade shows and speaks kind of on behalf of the company, maybe, demonstrates their product at these trade shows.
I agree. I think that's probably what we're looking at. Is that someone who we could put a label on them and say that they occupy a safety-sensitive position? I think that would be a stretch. I think that, typically what you're looking for with safety-sensitive positions are people who are operating heavy equipment, an electrician who is doing high-voltage connections, that sort of thing, but not necessarily someone who is involved in sales.
I agree. And also, we have to remember, this does not mean that this brand ambassador can be going to these trade shows after they've just used and they're under the influence and they're, high, representing the company. Now, that means they can use, outside of work and not come to work under the influence. But the safety position, I think would probably not. I think you'd be on the wrong side of the law if you terminated them for that use.
I agree. Okay, so let's talk for a few minutes about the drug policy that we think just about every company that's on the line should have. Some best practices, some do's and don'ts. And by the way, drug policies like this, as you'll see, they're not a one-size-fits-all. It's very easy for an HR manager or any individual to go online, do a quick Google search, sample drug policies, and find drug policies that may or may not be well suited for your company. Here's some of the issues that you need to be thinking about. Of course, you want to have everyone sign off on the drug policy. One of the first questions that you're going to ask is whether or not you want to test, particularly for marijuana. And there are a lot of companies now, some of the larger employers that are in Silicon Valley, .coms, have publicly come out and said, we're not going to test for marijuana. We'll do other drug testing. We're not going to test for marijuana because the law is just too murky and, we don't know where things are going with this, so we're not going to. I've also had employers that I've represented that tell me we want to test for all sorts of drugs, but we don't want to test for marijuana, not because of the uncertainty in the law, but because, frankly, it would disqualify so many of our employees who we think are otherwise qualified. We don't think it's good for business. We don't think that it's justified. What types of testing? Well, when you're developing your policy, you get to decide what types of testing. So there are generally 4 different types of testing. There's pre-employment testing. So pre-employment testing, when do you do that? And we have in the slide here, post-conditional offer. So you'd say, the job is yours, Mr. or Ms. Applicant. Congratulations. It's subject to one condition, and that condition is that you go ahead and you pass a drug test. Although usually it's 2 conditions. It's the drug test, and the second condition is a background screen. That's also the time to do that. There's reasonable cause testing. So we talked about that earlier. If I see someone who demonstrates erratic behavior, there's physical symptoms, I have reasonable cause, reasonable suspicion-based testing. Random testing. So I want to put everyone's name into a hat and pick out a few names each month or each quarter and have them go down for testing. That's fine in most states. Some states say you can only randomly test employees that occupy safety-sensitive positions. And for those of you in New Jersey, that is a rule in New Jersey that you have to deal with. So across-the-board random testing in New Jersey can be problematic. If you're considering it, you should consult with either one of us or another qualified labor and employment attorney. Post-accident testing. So you have an accident or a near miss, I'm going to have the person go ahead and submit for testing. Well, a few years ago, OSHA said, they issued a standard that said, no, you can't do that because no one's going to report accidents. They're all going to be afraid to. It's going to have a chilling effect on the reporting. OSHA's backed down on that now, but it's still something to keep in mind. What happens when the person tests positive for marijuana or cocaine or some other heroin, some other illegal substance, or they can test positive for a substance they have no prescription for? What do you do to the person? Well, you get to write the rules, again, in your policy. Should you have a zero tolerance policy, every single time a person tests positive, no matter what, we're going to fire them? When you put that in writing, you're boxing yourself in. And I've had many clients that have regretted that decision. They have a zero tolerance policy, and then they come to me and they say, I have a person who's worked for me for 20 years. It's a key project manager. I really can't terminate the person, and I've got this zero tolerance policy. Again, I think a better policy is one that has flexibility. That's what generally benefits the employer. Perhaps some progressive discipline would be warranted. We use last chance agreements in these circumstances. What's a last chance agreement? The employee tests positive and says, I understand I'm not getting fired, I'm being given a last chance, and that I'll agree to random testing and I'll be on probation for the next 12 months. And then in some policies, we put in a requirement that the employee participate in some sort of rehab. Other things to consider in your drug testing policy real quickly. The employee comes forward and says, hey, I have a problem. Do you want to terminate the person in that situation? No, of course not. You want to have provisions in there that talk about drug paraphernalia, possession of illegal substances. You want to talk about keeping and a representation or warranty in the policy that the company keeps the information confidential on a need-to-know basis. We want to talk about how the tests are going to be actually implemented. So, I understand there are problems that employers encounter all the time with employees bringing in urine samples that belong to others to try to fix or cheat a test. So how do the clients that I've dealt with try to avoid that? Well, they have a supervisor who stands right there and watches the person produce the urine sample. That's unlawful. There's case law on that. It's an invasion of privacy. Who should pay for the testing or retesting? I've seen employers put policies there, and that is uniformly, it has to be the employer that pays for that. Can an owner or a general contractor in a project require testing? The answer is yes. Can they require you to take an unlawful action to terminate someone every single time there's a positive test for marijuana? Of course, the answer is no. You are obligated to follow the law.
So, before we go into the next subject, we just kind of want to go through some big takeaways. Like I started with in the beginning, keep up to date on the state law where you do business. Some of the people on the line maybe do business in 50 of the states, and each law is going to be a little bit different, and it's going to be changing. From administration on the presidential level to just states changing. I mean, all signs lead to more liberalization in this area as we've gone from illegal at the federal level and illegal at all states to now, 34 states and territories having some kind of legalization. I don't think we're going backwards. I think we're going forwards, but it's just keep up to date on the law. Like Jon just touched upon, drug testing policy is a sensitive and necessary part of the employment agreement, but pick what's right for you. Not everything is just an out-of-the-box drug testing policy that we can recommend for everyone. The whole point of this first part of the webinar is think twice before just firing somebody that uses or tests positive for marijuana. And again, just the last point, it ties into the first point, is brace yourself for future changes. Just keep up to date on what is and isn't legal, just so you don't get yourself and your company in trouble. So the second topic is office parties. We're here at the second part of November as people start having office parties. In the office, outside the office, open bars, people, tending to get loose, enjoy themselves, and sometimes it's good fun and no harm comes, and sometimes people can have a little bit too much to drink or just misbehave, and it can lead to employer liability as others are affected by the person not acting appropriately.
And I'll tell you, Anthony, that in my practice, at least I would say a half a dozen calls each year from clients about issues that happened at their office party. So I guess this is, in a sense, a way to sort of learn from the mistakes of others.
Yeah, absolutely. So what law, we're the lawyers, so we want to talk about what law is implicated, of course, and the federal law here is Title VII. And what Title VII does is it prohibits employers from discriminating based on certain protected classes. And those classes are, sex, race, color, national origin, and religion. And this includes prohibiting sexual harassment and what we've all heard as a hostile work environment in the workplace. And that term is bold there and in different color because that's really a term of art, and that has been interpreted by courts based on different, factual circumstances and situations. And it's not the most easy thing to define, but, as the law develops and as it becomes more of a recognized and, important situation in the workplace, we get a better idea of what that means. And so what is the workplace? So, maybe for a layman, that means the brick and mortar where everybody comes to work each day, and that's it. When everybody leaves, they're on their own, and that's not the workplace anymore. That's not what the law says. If you have an off-site office party, it's paid for by the employer. Everybody is encouraged to attend, a lot of attendance, and it just so happens that this party is at an event space a mile away. Well, that's still the workplace because you still have the employer paying for it, encouraging the employees to come, and so that you don't escape liability just because it's not the brick and mortar that everybody shows up to every day. And then you can imagine the situation gets, even more tenuous. So trainings, okay, well, we're not down the street a mile, where everybody is in, we're based in Pennsylvania, everybody's in Florida for a training, and we're staying at a resort. Is that the workplace? Well, again, the employer, they're paying for this training. It's either required or encouraged that these employees attend, and that's most likely going to be the workplace. Meetings, again, if they're off-site, that doesn't get you out of what is considered the workplace under Title VII. Happy hours, again, if the employer is paying for it, encouraging employees, and just because it's at a bar, not at the workplace or not at the office, it can still be considered the workplace. Now, is it two employees that decide, hey, let's just go grab a drink after work, and if something happens between those two employees, Maybe, maybe not. If it's, the boss taking out one of, the employees that he or she supervises, and he's paying for the drinks, and it's encouraged as part of professional development, and that's different than two people that are kind of on the equal playing field, just going out to grab a beer on a Friday night. Again, sporting events, you can imagine it's the same kind of situation as we talked about. And so, what is a hostile work environment? To be unlawful under Title VII, for there to be harassment, it must check each one of these boxes. And these are legal terms of art that have special meanings. So the harassment, the act, or words spoken, whatever it is, it either has to be severe or pervasive. So severe, it has to be an extreme thing that happens, one time or two times, that is such a, hurtful or hateful statement. You can all imagine those things, such as, racial epithets or slurs that can be extremely severe, or it's a touching, a grabbing that, would be considered severe, or it's pervasive. So it's not rising to the level of a touching or a grabbing, or it is, a racial epithet, but it's inappropriate, it's uncomfortable, uncalled for, unwelcome, and it just happens all of the time, and such that it creates that environment that's unpleasant to work in. Again, it's unwelcome. So the person that is affected, it affects them in a negative way. It's not the situation where two people are at a holiday party and there's a DJ and there's dancing and they're both kind of participating in dancing and everything is welcome and consensual. That's going to be considered welcome, not unwelcome. They're both participating in this act. It's when one of the persons is affected and not welcoming that behavior. Again, it has to be objectively and subjectively offensive. So it has to be, a reasonable person would think that such conduct was severe, pervasive, unwelcome, that, it's a harassment, as well as subjectively. So the individual themselves is offended. So you can have someone that has a thick skin, as they say, and is less offended by certain contact, and then what us lawyers know as the eggshell skull plaintiff, that it's the person that can be offended by the slightest, comment, remark, or thing that somebody else might not be. So it has to be both objective and subjective. And finally, it has to be because of sex. So it has to be, for that reason, that person is being targeted or harassed. And John, before we go on, if you wanted to add anything to any of those elements.
No, I think that you covered them quite thoroughly. We did get a question, though, that related back to the drug testing, and just going on a tangent just for a second. The question was, if I make an appointment for someone to go get tested and then they don't show up, can I dock that person's pay for the cost of the test because they were a no-show? And the answer is, in most states, there are wage payment laws that would prohibit you from doing that. Most state laws on wage payments say that I can only dock the person if A, I get their written authorization from doing so, and B, if the deduction is for the employee's benefit. So as a general rule, docking people's pay as a punitive measure is a bad idea, including in this context. So let's continue on. We were talking about a hostile work environment. What sorts of conduct constitutes harassment? Well, Anthony mentioned a whole litany of different types of conduct. The one thing to keep in mind is that courts and the EEOC look at the totality of the circumstances. They don't look at the facts in a vacuum. They recognize that conduct in one setting on a construction site, there may be different things that are acceptable there versus what's acceptable in a law office or what might be acceptable at a holiday party. So, dancing and other activities that would go on at a holiday party, the law recognizes that those sorts of activities may not go on in other contexts. What about the person's intent? So I have a harasser who is an alleged harasser, but it's really just a good-natured person. We probably have someone like this at every company, or more than one person. The person who stands around the water cooler and tells jokes and stories. Hey, let me tell you about the date I had last weekend, or let me tell you about the episode of The Bachelor in Paradise that I saw last night, and they talk about it in detail. And they're just trying to be friendly, and people are generally, like the person. Does it matter what the person's intent is at your holiday party or in other contexts? The answer is no. Intent does not count even one bit. We talked about all sorts of different types of conduct, jokes, slurs, epithets. I would add to this list really memes, electronic communications, instant messages, text messages, because almost every case that I deal with now that has to do with harassment, there's electronic evidence that's right at the center of it. And of course, harassment can occur in a variety of circumstances. It doesn't just need to be the supervisor who is harassing a subordinate. So the cliche of the boss chasing the secretary, female, around the desk, that is not what harassment is all about. Harassment can apply to coworker harassment. It can apply to people of the same genders, the same or different races. It can be a female harassing a male. And yes, we have all sorts of cases that we deal with. This is not just an academic exercise. This is what we're seeing, especially in construction. We see a lot of male-on-male harassment as well. So let's talk about some hypothetical scenarios that were put together. Anthony, why don't we look at the first one?
Okay. Just take you through a couple of these to kind of, apply situations that you might see or could potentially see to kind of what we've talked about so far. So the first one here, Company X has branch offices throughout the East Coast. It flies in everyone for a big holiday party every December. It's really the only chance that people in different offices get to interact face to face. This year, two young single employees from different branch offices met for the first time and sparks flew. They were very demonstrative on the dance floor, and it was rumored that they spent the night together in a hotel paid for by Company X. No one complained, though, and Company X's owner didn't think much of the incident. And so you can think about this situation in, a couple of things that we talked about under office parties and sexual harassment. And so, you need more information in this situation to kind of evaluate if there was a situation. So, is this a workplace? Well, it sounds like this is definitely a workplace. You have the Company X bringing everybody in to a central location. Presumably they're paying for it. They're putting people up in hotels. And so maybe that's not the issue, but maybe the issue is what kind of conduct was this? Was it unwelcome? And also things to think about in this situation, did their conduct, was this unwelcome to somebody else, to an observer? And could you have potential liability in that situation? Was it just, a one-time situation and it wasn't extreme? Or was this really, use your imagination, was this really a extreme situation that anybody would think could be offensive to others? And so there's no, right or wrong answer in this situation. This is just kind of a scenario to get you thinking about the different situations.
Okay, so let's take a look at hypothetical scenario number 2. And by the way, if you have comments or questions, we still do have another 5 minutes or so. We can try to fit those in. So Hypo 2, Company Y has an open bar at its quarterly sales meetings. Last quarter, two sales managers got into an argument about who is the greatest NFL quarterback of all time. Neither was arguing in favor of Tom Brady, thank goodness. Eventually, things escalated and punches flew. One of the managers got clocked and suffered a concussion. So this is talking about another element of potential exposure to liability when you're talking about office parties. So if two people, managers in this case, get into a fist fight at an office party, what sort of exposure does the company have? Is that going to be something where we would have liability? Is that considered the workplace for really not for purposes of Title VII, but for purposes of workers' compensation law? And we could imagine other scenarios where someone drinks too much, slips and falls, and breaks a leg at an office party. Is it the workplace? And the answer is generally for all these purposes, it's the workplace. We have to make sure to follow the rules. We have to make sure that people are conducting themselves in a safe and appropriate manner. An office party is not akin to a wild fraternity party. It's got to be a place where people and their behavior comport to something that resembles a business-like setting, or else there's exposure to the company. And I know it's hard, and I know people are looking into having a venue, it's an open bar. Maybe it shouldn't be an open bar. I tell a lot of my clients, and looking at this scenario with the open bar, bad idea. Maybe give your people one or two drink tickets to try to limit the amount of alcohol that's consumed. So here are some of the thoughts on that: limiting consumption. Training, do we want to have training on harassment and or workplace violence? Sure. Is it a good idea to have that training around this time of the year, right before your holiday party? Yes, absolutely. Do you want to have policies covering non-discrimination, harassment, as well as workplace violence issues? The answer is yes across the board.
And we'll try to go through, I think, just one more scenario here, and then we'll leave maybe a couple seconds for any follow-up questions. So here we have scenario 3. After Company X's annual Christmas party, a group of employees decide to organize an after party at a nearby club. During the after party, one employee makes a pass at another and does so quite aggressively. And so in this situation, as the employer, what are the things that you have to think about and consider? And so, again, this is the workplace situation. Is the after party to the Christmas party, is that the workplace? So if it's, a manager saying, hey, everybody, let's go to the club, we're going to use my company card, that's probably more a continuation of the workplace. Is it a couple of, colleagues saying, all right, the holiday work party's over, let's us three go continue on? More likely than not, that's not necessarily going to be the workplace. And so, again, then we go to the conduct. Is that pass? And it says in so quite aggressively. Well, is it unwelcome? What's the severity of that? And the objective and subjective evaluation of that behavior. So, just again, another scenario that is not out of the ordinary that employers need to think of. So in our slideshow, as you'll see, we have another scenario, but we're at the 1 o'clock hour now. We don't want to take up too much of everyone's time. At the same time, if anybody has any questions, feel free to type them in. Feel free to call us or email us. So we're here to do is answer your questions and keep you informed and protected in these sensitive situations. So being that it's reached the time, I just want to say thanks on behalf of John and myself, as well as the firm, for joining this webinar. Please feel free to sign up for all of our webinars. We try to touch on hot topics in all areas that might affect you. I hope you found the information beneficial. Again, as we said, the slides and a link to the recording will be circulated with the follow-up email, so keep an eye out for that, and as well as on our website. Thanks again for joining us today.
Thanks, Anthony. I want to thank everybody on the line as well.
All right, everyone, enjoy the rest of your day.